Welcome, everyone, to Creating a Family. Talk about foster, adoptive, and kinship care. Welcome back to our regulars. You guys are what make us want to do this. But we also want to send out a special hello, welcome to our newbies. I'm Dawn Davenport. I am the host of this show as well as the director of the nonprofit creatingafamily.org. Today, we're going to be talking about the legal process for domestic infant adoption. If you're thinking about adopting, one of the first questions a lot of people have is, I don't even know where to begin. Obviously, this has something to do with legality. I mean, that much we might know, but where do I even begin? So today we're going to be talking with James Fletcher Thompson. He is a South Carolina attorney with extensive experience in the legal process for adoption as well as assisted reproductive technology. He is a frequent lecturer throughout the country on adoption and child welfare issues, and he's the author of a book published by the South Carolina Bar entitled South Carolina Adoption Law and Practice. He has received national and state recognition for his service on behalf of children and adoptive families, and he also serves on the board of Creating a Family. So welcome, Jim, to this podcast, Creating a Family.
Glad to be here. Thank you for the invitation.
All right, so we're going to begin with, just adoption is a legal process of transferring the permanent parent-child relationship from the parents of birth to the adoptive parents. And adoption provides the adoptive parents with all the rights and responsibilities of legal parents, just as if the child had been born to them. And conversely, the adoptee becomes the legal heir of the adoptive parents. So that's the legal definition of what we are doing. But now we need to dig into that. It's a lot more nuanced than that. So, Jim, what is like the difference between, we often hear public versus private adoption? What is the distinction there?
Sure. So all states have something akin to a Department of Social Services. That is when a child has been abused, neglected, or abandoned, and the state steps forward to take custody of that child, sometimes as a part of the foster care system, sometimes a part of guardianship. But it's when the coercive power of the state steps forward to seize control of a child when there is that abuse, neglect, or abandonment. Just to give you a sense of things, the South Carolina numbers, 97% of kids in foster care have been abused, neglected, or abandoned. Only 3% have been voluntarily relinquished.
That's pretty typical throughout the U.S., yeah.
I think so. And so private adoption, though, is the reverse of that. That's when a biological parent decides that their best parenting can be to relinquish the care to another person, perhaps a person that they're related to, such as a grandparent of the child, or an aunt, or an uncle, or a close friend, sometimes thought as a fictive kin, but sometimes just a place to an agency or another person who can assume that parental responsibility. So public adoption is social services. Private adoption can be private, meaning through an attorney or through an agency.
And today we're going to be talking about private adoptions. We do have a course on public adoptions, or adopting from foster care, for those who are interested. All right. So when you are doing a private adoption, it is possible to use either an agency, an adoption agency, or an adoption attorney. What are some of the differences there?
Well, I think I'm kind of uniquely qualified to have that vantage point because I am a private attorney doing those placements, but I also work with about 5 different agencies right now, helping to facilitate the placements that they do. And really, it is the end result is very similar. Process can be somewhat different. I think the differences have sort of blended over the years. I think it used to be that lawyers did these adoptions really without the social work input, to their detriment. I think in the old days, agencies did the same without the legal input, to their detriment. And today, I think both have recognized that adoption is a hybrid of law and social science. And so the agencies have lawyers that they fold in to look at situations, give legal advice to the adoptive parents and to the the social workers working with the expectant mom. And for instance, at our law firm, we have a social worker on staff because we recognize that adoption law is just a sliver of it. It's also working with a person at a very vulnerable time.
Hmm.
So those two things come together. Agencies sometimes have a mission, sometimes they are faith based, sometimes they're nationwide, sometimes they're state centric. Attorneys are attorneys first, adoption attorneys second, meaning they have that code of ethics that their bar association requires them to follow. So some adoptive parents like that process, knowing that the attorney is a fiduciary and that they need to advocate for the client, in that case, the adoptive parent or the birth mom. Agencies, it's somewhat of a, again, a kind of a hybrid where they may be a ministry or a mission to both birth, adoptive parents, and the adoptee as well.
If you use an agency, an adoption agency, they will have an attorney that is helping you facilitate the legal aspect. One thing I have noticed is that with adoption attorneys, in my experience, it is not common for them to have a social worker on staff. So I think that is unusual. And one of the things we encourage adoptive parents who are using an adoption attorney is to ask about the, as you say, the social service side of it. Who is going to be providing counseling to the expectant mom? And oftentimes you are paying in addition for that. I think in terms of an adoption agency as being a buffet, and that an adoption attorney is often more a la carte, where you have to think in terms of, all right, what are the social services that need to be provided? Training and education for adoptive parents, is another one that agencies, some provide and some don't in the domestic adoption sphere. Few attorneys do without adoptive parents first asking. Would you agree with all of what I just said?
I actually do agree with that. And I also think that the adoptive parents can help kind of call the question. I really admire an adoptive family who, if they're meeting with me or even with an agency, ask that question. What services are you providing to the birth parents? How
Hmm.
do they feel supported?
Yeah.
We're all a part of this, and
Hmm.
we want it to be something that we can look back on and speak to our child, the adoptee, years later, and to say that it was a process that was governed by mutual respect of all the
Right.
participants.
I love that.
Now that I'm the adopted parent of grown-ups, I have a unique perspective now looking back and knowing that each step that I have done, I want to be able to look them in the eyes and to say that it was
I
an
love that.
honorable thing to their birth parents who gave them life, and but for them, I wouldn't be a parent.
It's so well said. It's tempting to think at the beginning that I just want it done. And I don't want to do anything that could jeopardize this potential match or this match. And yet, for the strength of the relationship going forward, which is a lifetime relationship, often it's not always, but in an ideal world, your child is going to have access to the person that birthed them or to the people that are their biological family. So thinking about it up front makes sense. Another distinction is when adoptive families seek out and find an expectant mom on their own, or it can also be the reverse, where a pregnant mom or couple, realizing that they're not going to be in the best position to parent, seek out an adoptive family on their own. It could be called a number of things: identified adoption, independent adoption. I think it could be called any number of things. Talk to us some about that process.
Absolutely. I've been doing adoptions for 35 years, and I joined my dad in law practice, and he did adoptions before then. In those days, an expectant mom needed that go between, that intermediary to identify prospective adoptive parents. Prospective adoptive parents needed that intermediary to be able to find that birth mom. We just didn't have Facebook. We didn't have social media where people could reach out and network on their own. In many respects, adoption is better and worse for that. We can debate that, but it is empowering for a birth mom to be able to reach out to her family and friends and to be able to say, I'm facing an unplanned pregnancy. I need help. And then someone she loves or trusts to vouch for someone else. And that vouching for, that's the identified adoption, where she identifies an adoptive family, or the adoptive family puts out on their sort of concentric circle of friends and family. It might be a small, close knit group that they reach out to. It might be that whole, if you will, holiday greeting card
Yeah.
group. It may be
Yes.
their professional network and say, my wife and I are home study approved. We're ready to adopt. For some of you all would know, we've gone through 4 in vitros, et cetera, or something along that. And we're working with an agency or working with an attorney. We're home study ready. And if you know of someone facing that unplanned pregnancy, mention our name. And that sort of organic system of identification really works. Now, it's not for everybody. Some folks really don't love having, if you will, their business in the street and
Hmm.
kind of putting their most personal issues out there. But those who do can recognize that that's something that works well. And it can be reassuring to the birth mom who feels like she has a connection and is empowered in making that selection. And it's not ceded or delegated to some star chamber that she perceives perhaps as an agency might be perceived.
Hmm. That makes sense. So, another distinction is situations where a relative, it could be a grandparent, an aunt, an uncle, a cousin, adopts a child. In this case, we're talking more about infants, but within their family. Is there any distinction from a legal perspective when that happens?
There is. It can be more straightforward. In most states, it's a little bit more streamlined to adopt within a family structure. I actually think we will look back on that decades from now and wonder why we have made it as streamlined as we have, when I think for safety of children, there probably needs to be a more enhanced process to evaluate prospective adoptive families, not a lesser one. But in any event, today, you don't need to have the pre placement home investigation in the same way if you're a relative. You don't have to have the post placement supervision. The process, even coming out of foster care, which I know is not our topic, but many states are making that even more streamlined, where the home study process is more abbreviated.
Hmm.
And I guess the idea is that if the birth mom identifies somebody within her own family, she's vouching for them, and family should be that first source of potential placement. There's certainly federal law that says that we should first look to family. And then if there can be a timely placement, that could be the first choice. But then as we move on, step parent adoption, a grandparent adoption, a relative, there's a lot of the cases that we are handling. And that can be a good result for a child.
Okay. You mentioned step parent adoption. How does that, in this situation, you've got certainly a known person, it's the person married to the child's mother. Any distinctions there? I mean, there is a biological father, known or unknown. So, is there any distinctions there?
Well, of course, and there can also be our step parent adoptions where there's a biological mother.
Oh, valid point. Thank you for pointing that out. Yes.
And that's, the vast majority are the stepdad and adopting, but every family's got their own issues and every family's, complexion is different. And so those things can happen. In terms of difference, the process again is more abbreviated, but not the process of termination of parental rights. The process for termination of parental rights is the same, whether it be for an agency adoption or a public adoption or an older child or an infant. There still has to be a process where either that biological parent relinquishes parental rights by signing a consent voluntarily, giving up those rights, or the court judicially terminates those parental rights. And judicial TPR, termination of parental rights, is a process. Every state is different. Many states are similar, but many states are strikingly different in the grounds for termination and the process for adoption. It
Mhm.
usually governs of where the adoption is, where the birth mother gave birth and made that placement. Not as much where the family is living, the prospective adoptive parents, but where the placement is made
Mhm.
is often where the adoption takes place, and therefore it's often where the laws that govern that.
Okay. Yeah, we're going to come to that because that's a really good question. Before we leave this kind of general differences section here, I want to bring up the Indian Child Welfare Act. That is outside the scope of what we're talking about today. However, it is so important that I want to mention that if there is the possibility that the child or the expectant parents are connected with the tribe or are Native American, you must let your agency or attorney know this at the very beginning because a whole different set of rules and requirements are coming into play. And so I want to make certain that everyone knows that.
You say ICWA, Indian Child Welfare Act, and I'm afraid I have a little bit of PTSD on that one, Dawn, because I was the attorney who represented the prospective adoptive parents in the Baby Veronica case, which is a case on that same issue that went to the United
Right.
States Supreme Court and back down again. And so, if you will, let's underscore that. Let's highlight it and let's put it in blinking lights that if there's any Native American issue, it's something that you bring to the attention of the attorney or the agency, because that process is night and day different. Indian tribes, understandably and appropriately, have the care of the Native American child and the importance based on the truly long and lamentable history of removing Native American children from those families.
Right.
And so it's important to be careful of that. So I'll just underscore it, just what you said.
We have encircled that with blinking lights.
Yeah.
As well, we should.
I think when you talked about, I know we're going to get to legal risk later, but it really Native American, the Indian Child Welfare Act, the Interstate Compact, and birth father rights are the three sort of issues that are the legal risk issues that any family should be cognizant of.
All right, perfect. All right. So you alluded to this just a moment ago, and that, I mean, just for the onset, adoption is governed by state law, which means that it differs, as you pointed out, sometimes greatly between states. So, what law do the adoptive parents have to comply with? Is it the state where the expectant parent resides, or the state where the baby is born, or the state where the adoptive parents or prospective adoptive parents live?
So it's all of that. The question is which state's laws govern? Is it the sending state? Is it the receiving state where the expectant mom lived? Is it where the adoptive parents live? It really can be all of that because the ICPC, the Interstate Compact on the Placement of Children, is a compact among the 50 states. It is where the agency from the sending state must approve, but also the receiving state. So the state laws from both are, if you will, there's an overlay to the adoption from both states to make sure that the child's best interests are being served. When it comes to the law that is being applied, it is typically where the adoption is being finalized. Some states, like South Carolina, for instance, do not allow an adoption to be finalized in the receiving state of the adoptive parents. It has to be done in South Carolina. So everything is done under South Carolina law. Other states allow a child to be placed with the adoptive parents. They return to their home state and the adoption finalized there. If the adoption is finalized in the receiving state, typically, for instance, the birth father's rights and responsibilities are governed under the receiving state's laws, but always the law that applies to the birth mom, whether there is a waiting period, whether there's a revocation period, whether she can have counseling or is required to have counseling, whether she can have legal advice or is required to have legal advice, whether she's allowed to have reasonable living expenses paid or there's prohibition on that. All of those things are from the sending state, the state where the baby is born.
The state where she resides.
That's correct.
I don't know how often this happens, but that the state where she resides, the mom resides is not the same state that the baby is born in. Is that common? I mean, it seems like it would not be, but is that common at all?
Well, it's common in my practice because we have Charlotte, North Carolina, near the South Carolina border, and lots of people go there to deliver, or Augusta in Georgia, and people go to deliver. The
Okay.
ICPC, the Interstate Compact on the Placement of Children, has an understanding that ICPC is not applicable if the only reason that the baby was born there was for the birth mom receiving medical care within a certain radius of that home state. So if it's just for practical reasons or for medical reasons, it does not implicate that other state.
Right. If for some reason she has moved to the state, say, let's for instance, where the prospective adoptive parents live, and
Mhm.
she has moved there for the duration of her pregnancy or the remaining part of her pregnancy, what would happen then? She's from, let's say, Texas, but she moves to, let's say, California for her pregnancy.
That's okay. We have the right to travel in the United States. It's a constitutionally protected right. There have been 3 cases that have looked at that issue as to whether or not a person that travels during the pregnancy implicates, for instance, the Interstate Compact. It does not.
But so the law, in this case, the example I gave, she was living in Texas. She moved to California during the pregnancy with the intent to move back to Texas. What law would govern? Would it be Texas or California?
California all the way
California all the way, as long as she is residing in California. Okay,
when
interesting.
she delivers.
All right.
That's right. And if the baby's placed in California, no ICPC and California law.
All right. Let me take a moment to remind everyone that we have a Weekend Wisdom podcast that is a short form podcast, meaning 5 to 10 minutes, where we answer your questions. So we need you to send us your questions. You can click on the show notes and send them that way, or you can send them at info@creatingafamily.org. All questions are welcome and we really appreciate them. So listen to Weekend Wisdom, but also send us your questions. And now back to the show. Jim, in your practice and what you see throughout the U.S., what are some of the reasons parents make an adoption plan for their child?
It is so unique. And it's one of the real meaningful parts of my practice, getting to know an expectant mother and making that decision. There was an adoption we did yesterday in our law firm, and the birth mom was still struggling with her own addiction issues. And she realized the best parenting that she could do was to choose a family that was intact and ready, willing, and able, home study ready to take care of that. Now, because of that addiction issue, the Department of Social Services would have likely gotten involved if she didn't step forward towards a private plan. But that private plan, that private adoption, still gave her some agency in her own life. Agency meaning not in terms of adoption agency, but in terms of her own
Yeah,
decision making.
being able to choose the parents. Mm-hmm.
The flip side of that, and I've seen some data fairly recently from Creating a Family about the percentage of kids that are in foster care where there's drug issues is very high, but there's an overlay into private adoption where there's that
Mm-hmm.
issue of drug and alcohol. But that's not everybody. Sometimes it is a highly educated person of means, but still realizes that they're not ready. Maybe they're not ready. Maybe it's an unhealthy parenting partner that they would be forced to raise this child with that they think is not safe for them or for the child. There's a variety of reasons. There are married couples that choose the plan of adoption. I have one in my mind right now that worked with our law firm. She was successfully parenting 6 children, but she came to the end of recognizing that this unplanned pregnancy would really jeopardize the house of cards that they've really tried to build in that
Mm-hmm.
family. And they made
Mm-hmm.
a loving and unselfish decision to place the child for adoption. So it is across the board based on race and across the board based on age and economics, education. You can't pick out a stereotypical birth mom.
Is poverty often a factor?
It's probably a factor, but I don't find it to be a compelling reason. If anything, when times are really difficult, I find expectant parents having a hard time holding on to anything. They hold on to the child that they deliver. So I'm going to say no. It may be a factor as they consider sort of the totality of circumstances. I think it
Mhm.
clearly is a part of the totality of the analysis. If somebody's not working, or if they're not making ends meet, if they can't meet their own daily needs, and then it's more of a necessity. Yes,
Mhm.
that can be a factor, but not just because it might mean a little bit less or that they are having a little bit more difficult time. I don't see
Mhm.
finances as factored that highly.
And so many expectant moms now are already parenting children. So it's the impact of adding another child on the
Mhm.
children they're already parenting that is often, I think, persuasive.
So true. Most of the private adoptions, the birth mom is already parenting,
Mhm.
usually successfully parenting.
Right, exactly. So now I want to talk about some of the legal issues from the birth parent perspective. The first one, we've already touched on it, and so we don't have to go into great detail, but that is the whether they are relinquishing parental rights or parental rights are being terminated, or another way to say that is whether it's voluntary or involuntary. I imagine that comes in foster care, but perhaps in other ways as well. So talk to us a bit about that distinction.
Sure. So a birth mom can decide to voluntarily sign a consent, sometimes referred to as a relinquishment or a surrender. And that gives up her parental rights either to an agency or to the state or to an individual. You can also do a TPR, a termination of parental rights. That's where the court judicially terminates the rights based on certain factors that usually they have to be proven by clear and convincing evidence, such as a failure to visit or a failure to support or some sort of history of abuse or neglect. So those are judicial terminations. And in any given case, you might have one consent and one TPR. They could have two TPRs or two consents. Each case is unique.
Okay. So when can an expectant mom voluntarily relinquish her parental rights?
Anytime after the birth of the child.
All right. So it has to have the birth. Okay.
Yes. Mhm.
When can an expectant father, is there any difference, or does it also have to be after birth?
There are big differences about the way birth fathers are judged versus birth moms. In some states, they actually can relinquish the child prior to the birth. South Carolina, it needs to be post birth. But again, they can sign a consent or they can sign a voluntary waiver of their parental rights.
So it's state law. You're going to have
It's
to
state
look at
law.
the state. Some
That's
states
right.
allow fathers to, I don't think there's any state that allows a mom to relinquish her parental rights before birth. It's always after birth. But with a dad, again, it goes back to the differences in the states.
Yes.
Do expectant parents have the right to their own lawyer? I mean, if an attorney is representing the adoptive parents, does there have to be a separate attorney who represents the expectant parents or subsequently birth parents?
Sure. In a judicial TPR, termination of parental rights, where they're terminating rights against their will, and involuntary adoption. Yes, across the board, birth parents are often given an attorney, usually from the indigent defense at no expense to them. In a adoption, a voluntary release, different states handle it differently. For instance, South Carolina requires the attorney representing the adoptive parents not to be a part of that process where the birth
Mhm.
mother relinquishes rights, has somebody, either a lawyer or a certified adoption investigator, meaning somebody with extra training in adoption, to be there to advocate for that parent. But for instance, over the state line in North Carolina, it can be done by the attorney for the adopting parents. Each
Mhm.
state's different.
Okay. Again, so each state is different. What happens if this is not the usual? My question is, what happens if the expectant parent is a minor? Most, at least moms who are relinquishing in domestic infant adoption, are not minors. That is a misconception, I think. But there are certainly people below the age of 18 who are making an adoption plan. So anything different if the mom is underage?
She still has the right, whether she be underage, if she's a minor, to still choose an adoption plan, even if that is different than what her parents or guardians would have her do. In South Carolina, there are no additional protections other than just good practice and common sense. what is voluntary, not subject to duress or coercion for a sophisticated 30-year-old might be a different process for a 15-year-old person who might be less sophisticated. So
Mhm.
you have to bring in some common sense to the process and hopefully make sure you have adoption professionals who are sensitive to her unique needs to be a part of it.
To make sure that she's actually voluntarily doing it. So, how long after birth parents sign the papers for voluntary relinquishment, how long do they have to change their mind?
So the question you ask is really twofold. Does your state have a waiting period? And does your state have a revocation period? So a waiting period often is how long after the birth before a birth mother can be presented with the relinquishment documents. For instance, in South Carolina, we have no waiting period. Some states, it's 36 hours after birth. In South Carolina, we impose upon ourselves a 24-hour rule of thumb, even though the statute doesn't discuss that. Then the next question is revocation. How long can she to change her mind? In Georgia, for instance, our sister state, she has 4 days to change her mind. North Carolina, 5 days, where you can simply say, I made a mistake and I want the child returned to me. This is usually after the baby's already home with the adoptive family. South Carolina has no revocation period. And yet, our process is a little bit more rigid about how the consent is done. So all of those things kind of come out in the wash.
Do you know of the range of revocation periods, which is, of course, what many adoptive parents are worried about?
Yeah.
Do you have a feel for the range of the different states, the largest revocation period?
I haven't looked recently. Last I looked from Maryland was 30 days. It certainly was 30 days a while back. Whether that's been addressed again, I'm not sure. We've had plenty of situations where you asked earlier, what if a South Carolina birth mom delivers in Georgia or delivers in North Carolina? We've given them the opportunity to say, do you want to choose Georgia law and have a revocation period, or North Carolina law, have a revocation period? Or would you rather choose South Carolina law, have no such revocation period?
During that revocation time, do they have to have a quote good reason for changing their mind, or can they just change their mind?
Just change their mind. That's a good reason enough.
Okay.
Yeah. But I've never had one time choose that revocation period. The finality and permanency of knowing that you've made a voluntary decision that's in the child's best interest and that the family can rely on that and you can rely on that decision. The harder question comes with how long does that birth father have post placement to come forward and to raise his hand to be able to object?
All right, let's talk about that.
So South Carolina, that time, his judgment is at the time of placement. Has he lived with that birth mother for 6 months consecutively? Has he contributed a fair and reasonable sum of money? That's how we judge whether his consent to the adoption is required. But if you want to go to Pennsylvania, that man has 120 days to come forward. So really different from state to state. And in South Carolina, for instance, a birth mother has the privacy right not to identify that birth father, whether she knows him or not. She can choose not to name him. In North Carolina, not so much. There's a strong preference towards naming a biological father. So again, state by state, the process for the birth mother, but also the grounds that we look at the birth father's rights can be different from state to state. And a lot of that boils down to whether that state is one of the 34 states that has a responsible father registry or thought of as a putative father registry, the database that allows John Doe men to come forward and sort of raise their hand and say, I could be a father. And they register under the name of the birth mom. And so when the agency or the attorney is doing the adoption, they check the birth mother's name on this confidential database. And if a man signed up, he's be a possible father for that child born to that birth mother, then he's given notice. And so to me, one of the most important legal risk issues is birth father issues, and finding a state that has a putative father registry is a key to addressing that legal risk.
Okay. All right. And just briefly talk about the importance, again, we're speaking about birth parent rights right now, the importance of counseling, regardless of whether you use an adoption agency or an adoption attorney.
Right. So options counseling. the decision to be able to make a meaningful decision for that expectant mom. I think it's in everybody's best interest, and most importantly, the child, to know that their birth parent was given that opportunity to weigh those choices and to have an adoption minded person. You can be a wonderful counselor, but if you're not a counselor that understands unique issues of adoption, you're probably not serving that person well. You can be a great lawyer, but if you're not understanding of adoption related issues, you're probably not serving that client well. And that's one reason why people go to adoption agencies, because it's a unique area of law and social work that comes together that serves the needs of the triad, the adoption triad, the birth parents, the adoptive parents, and the adopted.
Let me pause here to thank Vista Del Mar Adoption Agency. They have been a longtime supporter of Creating a Family, the nonprofit, as well as this show. Vista Del Mar is a licensed nonprofit adoption agency with over 65 years of experience helping to create families. They offer a home study only service as well as a full service infant adoption program. They can also do international adoption home studies as well as post-adoption support. And they have a foster to adopt program. They're located in California, and you can get more information about them online at vistadelmar.org/adoption. And now back to the show. All right, now let's move to talking about some of the legal issues in adoption from the adoptive parent's perspective. One thing we haven't talked much about, and that is it is required that I think in all 50 states, that adoptive parents have a home study and background check requirements. Who does that process?
Yes, you have to have that pre-placement home investigation and post-placement report, usually done by the agency, or can be private certified home study providers in the states that can do that. It's not just any social worker that can do an adoption home study. It's unique. And so families often say, well, I've got a friend who's a social worker or who works for Department of Social Services. I'll have them do my home study. An adoption home study is very different from a foster care license or from any other thing that's called home study. This is an adoption pre-placement home investigation with unique criteria that's statutorily driven.
All right. Another legal issue that can come up, and this goes back to what we were discussing about where the adoptive parents identify or find an expectant parent on their own. Can adoptive parents advertise to find expectant parents who are considering placing their baby?
It's a state by state requirement. South Carolina allows it so long as they have a home study, and different states have that rule. But it can be a criminal violation to advertise in some states, and criminal violation if you are not home study approved. So you have to be mindful of that for sure.
How does that work on social media? Is that considered advertising? If you are posting on social media, look, we are looking to adopt. If you know of someone or if you yourself are considering, please let me know. Is that a risk for adoptive parents?
I think if they have a home study and they are approved, I think that that's a safe bet. Those laws primarily went into effect where there were yellow pages, if any of us remember those days, when non-licensed agencies, facilitators were advertising adoption services and they were not licensed or accredited or in any way accountable. And those were those groups primarily. But as long as a family has that licensed home study and they're doing that on their own social media, I think that's appropriate.
All right. You have alluded to this earlier. Can you restate what we call a legal risk adoption? Can you restate I think you said there were 3 issues that could come up that make an adoption risky going forward?
Yeah, the 3 things that I think are the most significant legal risk issues are: one, the federal law, the Indian Child Welfare Act, ICWA. If the child is a Native American child who's a member of a federally recognized tribe, the rules are just different there. And so that's an important hallmark of legal risk is ICWA. The second is making sure that the requirements of the Interstate Compact on the placement of children, the ICPC, are adhered to, which is this compact among the 50 states that says that both states have to agree before a child can move from state A to state B as a preliminary to a possible adoption. And honestly, that happens a lot.
What are some of the issues under the ICPC, Interstate Compact for the Placement of Children? What are some of the issues that would come up that parents need to be aware of that they wouldn't automatically think of that they need to make certain that they are adhering to?
Well, it's largely procedural. It requires the sending state to look at the medical and social history, look at the home study, look at all of the documents that freed this child for adoption to make sure that they're done under state law. And then they're also reviewed by the receiving state to make sure, for instance, if this child has special needs, that adoptive parents have a home study that approves them for the placement of a child similar to that child. So that sometimes takes time, and it might be a week, sometimes more, before the adoptive parents are free to return to the home state.
So it's a legal risk technically, but as long as you're following the process, which is well laid out.
Yes.
Right. All right.
Honestly, the biggest legal risk of ICPC cases is working with an attorney who dabbles in adoption and did not recognize the ICPC's applicability.
Okay. That makes good sense. All right. And what is the third legal risk that you were referring to?
Birth father issues.
Okay.
Recognizing that birth fathers have a legally recognized, constitutionally protected right, so long as they have done certain things. And those things usually are defined by state law. But if that man has seized the opportunity that the biological connection afforded him, his consent to the adoption is required, just like a birth mom's. But if he hasn't, the adoption can go forward without his consent. That is very state specific. So in South Carolina, he has to have done certain things. He has to have stepped up, if you will, have been an earnest father. Has he lived with her? Has he offered to? Has he contributed financially? And then the next question is, did he, if you will, raise his hand as the father? Did he register with the putative father registry, which 34 states have, that allows there to be this database where a man who is not named, meaning a John Doe, he's not on the birth certificate, he wasn't named by the birth mother in the consent document, but he can name himself by virtue of registering with this database under the name of the birth mom. And then we check the birth mom's name. And again, it's a confidential database. Not everyone can just go on here and to search these records, but an adoption agency can, an attorney can, to see if a man has claimed paternity. If he's claimed paternity, he's given notice and an opportunity to be heard as to whether he's done those things necessary. If he hasn't signed up, that's usually, in most states, an implied irrevocable waiver of his right to receive that notice.
All right.
So there's no more publications in newspapers and things of that nature. So the legal risk issue is, have we dealt with the birth father in an appropriate way, given him an opportunity to be heard? And if he has done those things, given him the right to be a participant in the adoption? And if he hasn't, it gives us a way to move towards permanency for that child more promptly.
So, what rights do adoptive parents have after a match? They have been matched with an expectant parent. Parents or mom, they've met with this person, they have had a baby shower, they have started dreaming about this child, but the expectant parent, the child has not been born, and the expectant parents have not relinquished their rights. What rights do the adoptive parents have?
None.
And that's a hard pill.
That's really why I don't like the term failed adoption, because a failed adoption looks at the adoption from the adoptive parent's point of view and not the child's point of view.
Mhm.
It may very well have been the appropriate decision that expectant mom came to, even though she thought about adoption for a while and maybe even committed to it. But she has complete agency. She has the right of making her own decision all the way through to the time that she signs and through the time of that revocation period. And so the adoptive parents cannot assume that that child is theirs or assume any rights until the law bestows those on them.
All right. So, What is allowed pre-birth, prior to birth? Can adoptive parents and expectant parents meet in person? Is it required? How much medical history is shared between them? Is there anything in that process that after there has been a match or after a expected parent has been identified, is there anything legal that we need to know and that we need to be careful of during that period?
There are many times when prospective adoptive parents meet with the birth parents, have a rapport that's built, have an understanding, perhaps even discussing what things look like post adoption. But that does not transform the case to any kind of rights for the adoptive parent. It continues to be completely in the birth mom's, really the birth parent's decision up until the child is placed and the consent is signed.
All right. Now, post birth, let's talk about open adoption. Sometimes it is just a verbal agreement between the adoptive parent or parents and or at this point, the birth parent or parents. It's what they've talked about, what they verbally agree, but sometimes they have a written document. Is that written document enforceable?
So these written documents, often referred to as PACAs, post-adoption contact agreements. There's a growing trend in states to recognize a PACA. A PACA is, I think, last I looked, in about 30 states. That would allow enforceable agreements, post-adoption contact agreements. South Carolina, for instance, is one of the states that does not have that, but it's been introduced in our legislature this year. For those states that don't have a PACA where you can actually enforce post-adoption contact, it's really kind of a good faith understanding or an agreement. They're often done where the birth parent says, may I have some pictures? May I have some updates? Perhaps a meeting once a year. When people are first coming into adoption, they may think that that open adoption is driven by birth parents. Not so much. The more that adoptive parents learn about the impact of some connection, some bridge to the birth family, and how important that can be to a child, I'm seeing more and more adoptive parents be the one that reach out and say, can we have a relationship? Can we have a mutual respect and understanding over the years? Because at age 6 or 8 or 12, we may be reaching out to you to gather information for that child.
Mm-hmm. Interesting. Yeah, things have changed. The child is often placed with the adoptive parents right at birth or right after birth, released from the hospital to the parents. But when is the adoption usually finalized?
6 months or less for an infant adoption, I would say. And again, that's state by state. Some states have certain waiting periods before an adoption can be finalized, but 6 months or less is a good rule of thumb.
During that period of time, who makes medical decisions for the newborn, or for this case, a 5-month-old or 4-month-old?
Right. So during the pendency of the case, waiting for the adoption to finalize, the adoptive parents still have custody. And then post adoption, they are the adoptive parents. So they're still making all the medical decisions for the child. They can place the child on their medical insurance. For instance, federal law treats a child through adoption the same as a child by birth. Those protocols, if you will, are pretty straightforward.
Does the birth parent have to show up in court for the finalization? Or does anybody have to? Is it handled in court? And if so, do the birth parents have to show up?
It's funny, the court hearings, birth parents typically do not show up. Their waiver that they sign, the consent document, waives notice of a final hearing. If their rights have been terminated, that they're not given notice of a final adoption hearing. Once in a while, things are so cordial that the birth parents come to a final hearing, but not usual. And then state by state, really different. One of my colleagues is an attorney in California. Sometimes it's done virtually or even over the telephone. In South Carolina, it's very formal, where you come to court and dress for court, get sworn in, take the stand, and are asked very difficult questions like, do you love this child?
Yeah.
And do you understand adoption is forever? But
Mhm.
it's a beautiful moment to be able to kind of
Yeah.
a public expression of your love for the child. And
Oftentimes, the whole family comes, and
yes,
you get the
yes,
picture of the baby, you holding the baby, and the judge gets to smile in your picture, and it's a part of your family photo album. Yeah.
absolutely. It's the only time that judges smile.
So, an interesting thing that some people don't realize is that the original birth certificate has the biological parents, if the birth father has been identified, has both parents listed. But then it is amended at some point, and the adoptive parents are listed on the birth certificate. So, two questions. When does the birth certificate get changed so that the adoptive parents are listed? And how can adoptive parents get a copy of the original birth certificate for their child? Adults or teens often would like a copy of that one.
Yeah, absolutely. So the amended birth certificate, if you will, the adoption birth certificate is after the adoption is finalized, but there's no mention of adoption on that document. It simply has the mom and dad listed there as the adoptive parents without mention that it had ever been amended. The original birth certificate is a valuable thing. And in an open adoption where everybody knows everybody and there's a free flow of information, there are times where that birth parent will supply that to the adoptive parents as a keepsake, something that is kind of put aside for later to be able to have that sense of the beginning stage of life.
Hmm.
There's a connection to that birth family, but not so in many states. I, for instance, could not give an original birth certificate to a client because it's protected under the confidentiality statutes. So unless the birth parents and the adoptive parents have that understanding and do that themselves, I can't facilitate that. And last I looked, only 3 states have a complete open records to allow an adoptee after age 18 to go back and have that original birth certificate.
So I guess the bottom line here is that if you want to be able to give that to your child, the time to do that is after, obviously after birth, but by working directly with the child's birth parents.
Yes.
All right. And as boring as it might be, we do have to have a Social Security number. All of us do. Can adoptive parents get that for their child? And do they have to wait till after the adoption is finalized, or can they do it when they have custody of the child, but they're waiting for that, 4 to 6 month period before they go to court or appear and have the adoption finalized?
And perhaps I'm not the best person to ask because I happen to know that my wife went to Social Security 3 different times before they finally gave us the Social Security number because they wanted all sorts of proof. So I've learned from that experience. And now for my clients, I explain that you wait for the adoption to be finalized, you wait for you to have your birth certificate, and you go to Social Security with all sorts of proof of where you live and how long you've lived there. That's when you would get that done. That's when the Social Security card would be issued. But prior to that, our babies are not born based on the IRS timeline. And so sometimes we have taxes to take care of. And so there's an adoption identification number. There's a way of being able to claim a child for your taxes before you have that Social Security number. You can actually use that over a couple of years.
All right. Well, thank you so much, Jim Thompson, for talking with us today about the legal process of domestic infant adoption. We truly appreciate your expertise.
My pleasure.
And before you leave, I want to thank the Jockey Being Family Foundation for their support of both this show and the nonprofit Creating a Family. And it's through them that we are able to offer you free courses. We have 15 courses on our Jockey Being Family page on our website. They're focused on parenting, and they're terrific. If you need a certificate of completion, you can get one. If you don't need one, you should still look through the courses. You could do that by going to bit.ly/JBF support. That's bit.ly/JBF support.